Welcome, everybody, to the August 2nd, 2022 meeting of the Salem Planning Commission. Shelby, would you please call the roll?
Commissioner Augustine.
Here.
Commissioner Ekus.
Here.
Commissioner Fott.
Here.
Commissioner Goebel.
Here.
Commissioner Griggs.
Here.
Commissioner Heller.
Here.
Commissioner Levin.
Here.
And Commissioner Slater.
Here.
We have quorum.
Thank you, Shelby. We don't have anybody signed up for public comment at this stage. We'll move to the consent calendar, but before I look to Commissioner Goebel for a motion, I do want to put on the record that I did listen to the July 5th hearing so I can participate in the vote. So, Commissioner Goebel, do you have a motion?
I move to accept the minutes from the July 5th, 2022 meeting.
Great. Thank you, Commissioner Goebel. Do we have a second?
I'll second.
Thank you, Commissioner Fott. Discussion on the motion. Shelby, will you please call the roll? Signify by saying aye if you're in favor of the motion and nay if you're opposed.
Commissioner Augustine.
Aye.
Commissioner Ekus.
Aye.
Commissioner Fott.
Aye.
Commissioner Goebel.
Aye.
Commissioner Griggs.
Aye.
Commissioner Heller.
Aye.
Commissioner Levin.
Aye.
And Commissioner Slater.
Aye.
Thank you, Shelby. Motion passed. Moving on to public hearings. Item 5.1, appeal of the tentative subdivision case number SUB 22-04 for the 3600 block of Boone Road Southeast. Are there any ex parte contexts or potential conflicts or actual conflicts of interest to declare amongst the commissioners? Seeing none, we'll look to Shelby for the statement of criteria.
This is a public hearing to consider an appeal of tentative phased subdivision case number SUB 22-04 for a property located on the 3600 block of Boone Road Southeast. The criteria applicable to this application are found in the Salem Revised Code, SRC, Chapter 205.015D for phased subdivision tentative plan. Failure to raise an issue prior to the close of the public hearing with statements or evidence sufficient to afford the Planning Commission and the parties an opportunity to respond to the issue precludes appeal to the Land Use Board of Appeals, LUBA, on that issue. A similar failure to raise constitutional issues relating to proposed conditions of approval precludes an action for damages in circuit court. Prior to the conclusion of the hearing, any participant may request an opportunity to present additional evidence or testimony. The Planning Commission will then either continue the public hearing or leave the record open for at least 7 days.
Thank you, Shelby. Mr. Panko, you're up.
Thank you. Can you hear me?
Yes.
I'll share my screen here. Good evening. My name is Aaron Panko with the Planning Division. At this time, I'd like to enter into the record the staff report, including all of its attachments. And this is an appeal of phase subdivision tentative plan, case number SUB 22-04. The property is highlighted here in the center of the screen. It's approximately 79 acres in size. This property is located outside of the urban service area. It has a frontage along 2 streets, Boone Road to the north, which is designated as a local street, and 36th Avenue Southeast is located to the east of the property. It's designated as a minor arterial. The property also has frontage along Interstate 5 to the west. This is a zoning map for the property. Property is zoned IC, industrial commercial. Surrounding properties to the north are zoned IG, general industrial, and commercial office, CO. Those uses to the north include a senior living facility and some residential uses. Property to the south is zoned RA, residential agriculture, and is undeveloped. The area that's not shaded on the east side of the site here It's outside city limits. The comprehensive plan designation for these properties is industrial, and then further to the south is a more residential designation. And this is an aerial photo of the site. So the 79 acres is largely undeveloped. There's a single family home here to the center. There is a mapped waterway that crosses through the property here, and there's some trees that are located kind of in the southwest portion. The planning administrator approved a phase subdivision tentative plan on June 14th to divide the subject property in 2 phases of development. Phase 1 includes 9 lots. Lots 1 through 5 are on the western portion of the property, and then lots 6 through 8 are on the eastern side. Lot 9 kind of straddles the street here in the center. And with phase 2 shown on the screen, lot 9 would be further divided into lots 10, 11, and 12. There have been some recent land use approvals too for this site. There has been a conditional use permit granted for development of a 210 unit multifamily apartment complex. It spans lot 1 and 2. There was another conditional use permit for 272 unit multifamily residential apartment complex and townhome development that was approved just recently for lots 3, 4, and 5. And then there's a site plan review decision that was approved recently for some flex industrial commercial spaces. These are shell buildings on lot 7 and lot 8, and then a self-service storage use for lot 6. And there's no development plans at this time for lots 10, 11, or 12. This is a photo taken of the site. This is from Boone Road, looking to the southwest. So these are some of the trees we saw on the aerial photo. I-5 would be down the ridge on the other side here, out of view. And this is a photo taken from Boone Road, looking east. So Boone Road's here, 36th would be along this way. With the initial application, the applicant requested relief from a street connectivity standard, citing concerns with wetlands in the area and questioning whether the 600-foot street connectivity standard should apply in industrial areas such as this. After review of the application materials, the planning administrator denied the request for relief and issued a decision approving the subdivision with a condition requiring the applicant to provide a street connection from proposed 32nd Avenue to the southern boundary of the property. And the approximate location for that street is highlighted here in the red between lots 6, 7, and 12. The arguments raised in the appellant's letter, followed by a staff response, is found in the staff report. In summary, the first argument is that the planning administrator did not provide substantial evidence or adequate findings in support of the decision to require this additional street connection. In response to the applicant's statement that the 600-foot connectivity shouldn't apply to industrial areas, the standard applies equally to residential, commercial, and industrial zones, and is further applicable in this case, given the mix of uses that were already been approved for the site. Local streets provide alternative routes and options for vehicles, bicycles, pedestrians, which enhance circulation in the area. And regarding the concern for wetlands, if at the time of future development, the applicant can demonstrate that construction of the public street would be impacted by a mapped wetland and a permit cannot be obtained by the Department of State Lands for that impact, the additional street connection would not be warranted, would not be required. Excuse me. The second argument is that the city is using the Salem Transportation System Plan as the basis for requiring the additional street connection. The city does have adopted street connectivity and block length standards that are codified. They're found in Salem Revised Code Chapter 803. And the subdivision approval criteria require that an application for subdivision complies with all applicable provisions of the Salem Revised Code, including city infrastructure standards. The third argument is that this is an application for needed housing, and therefore the provisions of state law ORS 197 allow the city to only use clear and objective standards in the review process for this application. This property is zoned IC, industrial commercial, and there have been 2 land use approvals granted for development of multifamily uses on the property. Future uses of lots 9 through 12 are unknown at this time, but they could include multifamily residential uses. Chapter 803 does provide clear and objective standards regarding street connectivity and street spacing. Relief can be granted from the street connectivity standards. However, a decision by staff granting relief from street connectivity standards would involve the use of discretion, which the city would be prohibited from doing if this was a needed housing application. And the final argument raised is that the planning administrator's decision violates the takings clause of the Fifth Amendment of the US Constitution and Article 1, Section 8 of the Oregon Constitution. And staff concurs with the applicant that it is the city's burden to adopt findings that demonstrate the proposed street connection is proportional to the applicant's impact on the transportation system. Without knowing future uses or if the property may be further divided at some point in the future, the actual impact of the transportation system regarding like lot 12 is unknown at this time. So staff is recommending that the Planning Commission remove condition 19 from the subdivision decision and instead adopt the finding that street connectivity needs will be further assessed at the time of future development on lot 12. Notice of the appeal was provided to the Neighborhood Association, Southeast Mill Creek Association, and surrounding properties. And there was no public comment received during this notification period. And staff is recommending that the Planning Commission modify the decision of the planning administrator by removing condition 19 and approving the subdivision. Thank you.
Thank you, Aaron. Questions of Aaron at this moment from the commissioners? If you could, Commissioner Goebel?
Thank you. Okay, Aaron, so my first question is regarding, I guess, typical process. And when it comes to when this was being reviewed, I guess I'm curious, first of all, why the street connection was added as a condition of approval. Was that something that was discussed with the applicant during the application process, or was it something that was can you just explain that to me as far as the procedure there goes?
No, we did have some conversations with the applicant regarding the street connectivity here. It is a large site, and the applicant has requested relief, and we did grant relief from some of the street connectivity requirements. The code does require every 600 feet that there's a street connection. We have a large undeveloped property to the south, and there's one street connection that's proposed here. So again, during the initial assessment here, it seemed like this connection is warranted by code, and there would be a potential need for this by future development.
Okay. Did you have a follow-up, Commissioner Goebel?
Yeah. So follow-up question then is, if this is approved without the street connection, and then lots 6, 7, and 12 are then sold and developed by separate applicants, that can you explain, I guess, if this is a connection that the city sees as being beneficial and necessary to connect to large undeveloped parcels, is it not likely that, since those would likely be developed with different impacts, different timing, and so forth, that even if that right of way is dedicated at different times, I guess, can you explain to me like the benefit of waiting until development to have that street connection built in, and potential risks of it not being put in?
I think we have to know more about how lot 12 is going to develop in the future. The city, again, is required to make a finding that any requirement for dedication and construction of the street is proportional to the development that's proposed here. And at this time, I don't think we have enough information to make that assessment. So we really need to know what's going to occur here before we can make that decision.
Okay, so are Yeah, is it, are you guys requesting that the right of way for that street be dedicated at this time, or I guess,
No. So the condition would require dedication and construction. We're recommending removal of the condition. So this is essentially granting the applicant's request for relief from building the street with the subdivision application.
okay, so if it's a code standard, I'm sorry, Aaron, I really want to get clear on it. So if it's a
Mhm.
code standard that there's that street spacing standard be applied, I guess why wouldn't we still require the right of way dedication, even if we're not requiring a proportional impact to actually construct the street?
I mean, maybe Tom or Glenn, who are listening here, might want to chime in.
Let me try. This is Glenn Davis. I'm the Chief Development Engineer of Public Works. As part of the application process, we met with the developer quite a bit to try to figure out ways to mitigate their concern. And that did come up is can we just do right of way only? And their objection was that lacking a development plan for lots 11 and 12 and the wetlands, they don't know where to put it. And so the right of way, if we just guess and we guess wrong, then that's a vacation process. It's a whole other process. So they objected to that. We did propose that as an option, and they did not think that was a very reasonable mitigation. So that's why we haven't come back with that as a proposed option.
Follow up, Commissioner Goebel?
So yeah, that's helpful. I think then the second part of my question, maybe if Aaron can go into detail on, are we risking that connection not being built, or is it something that the city's concerned about at all? And that's kind of my final question.
Okay.
I mean, I think it's possible that it wouldn't be built if the connection, if the city can't make findings that it's proportional.
Are you good, Commissioner Goebel?
I think so. I think I'm
I
still
can come.
yeah, maybe I might want to come back to that just because I'm confused about how they're not meeting the standard there, even if they're not being built. But I appreciate that. I'm a little more clear than I was prior. So
Okay,
thank you.
I'll loop
Thanks,
back
Aaron.
to you before we leave that section of our agenda. Commissioner Ekas, followed by Commissioner Slater.
Thank you. I have several questions, some of which will get to the same issues that I think Commissioner Goebel mentioned, but I need to clear up some confusion I have first. Mr. Panko said that they denied the requests for the alternative street standards, but as I understand it, the only one that was denied was the 1875. As I read unless I'm reading the wrong thing, what I read in the initial order was that trying to find it here, but that they approved three of the requests, two for a little over 700 and one for the 1785, but it was the 1845 or so that they denied. And yet I thought Mr. Panko said, and the staff report says they denied the requests for alternative. And as I read it, the only thing was denied was the request for the 1845 feet, and that was because of the circumstances that led to condition 19. I wonder if he could clear that up for me, because I'm not under the impression all the alternative street standard requests were denied.
That's correct. We did grant other exceptions to the connectivity requirements. I mean, the standard does require streets every 600 feet. Based on the size of the property, there would have been, I think, 2 additional streets required along the Boone frontage. There would have been an additional street required along the 32nd frontage. And then there would have been a few streets required along the southern boundary here. So again, we did grant relief from some of those street connectivity requirements. The one that we had disagreement with the applicant on is the one that's highlighted here leading to the south.
Follow up, Commissioner Ekas.
I'm sorry, can you the one that's highlighted leading to the south is that one. And condition 19 applies to where then?
It would have required the applicant to build the street in this
To
location.
build that street.
Yep.
Okay.
We thought that this wasn't, we wanted the street connection originally.
So that's the basic issue here. It's not
Yes.
the others.
Yes.
All right. I found that a little confusing when I read the, I have a couple questions based on that regarding some of the comments in the staff response. I need a clarification or more elaboration on the response to on your recommendations to eliminate condition 19. You discussed flexibility, and you said at the time of future development, the applicant can demonstrate construction of a public street would impact a mapped wetland and a permit cannot be obtained, then an additional street connection would not be warranted. And then you said that relief can be granted for street connectivity. However, that would involve the use of discretion, which wouldn't be allowed under ORS 197.307. And that would also mean that other requests made by the applicant for relief that have been granted should also not be granted or applied. I'm paraphrasing, but this seems like not only a catch-22, it seems like two catch-22s, maybe a catch of 44. If the subsection allows relief to be granted, but that involves discretion which is prohibited, that doesn't make sense to me. Can you explain that?
Sure. One of the applicant's arguments was that this is an application for needed housing, which has requirements that staff only apply clear and objective standards to review of an application like this. So if this was a needed housing application, the city would not be able to use its discretion in granting relief from the standard. The applicant would have to meet all of our standards for street connectivity, if that's how they wish to apply the needed housing provision.
Okay, I need to check on that, if that was in that section. So basically what it comes down to, as I understand it, is that you were deciding in response to the violation of the takings clause argument that you agree that the burden is adopt findings that demonstrate the condition is proportional to surrounding transportation system. And you're saying that since the actual impact is unknown, that it's only until the future use of property lots of lot 9 or lot 12 has been determined whether or not, can you decide whether or not a street may be warranted. So am I correct that that's basically that on all the other arguments that were raised, the staff disagreed with those arguments, but on the arguments under the violation of taking clause, staff has decided that because it's unknown, we can't make a decision until we know the future use of the property.
Yeah, that's correct.
Okay, so my question then, and I think it's going to get back to what Commissioner Goebel raised, is this was an issue of violation of the taking clause. So I'm wondering, in which there was I'm not going to call it a threat, a notice that they would pursue this issue, and if they won, then city might be liable for attorney fees and some other things. Are you conceding that it violates the taking clause, or are you just mitigating the risk?
Tom,
let
are
me,
you?
jump in there?
Yeah.
We're not conceding that there was a violation. What we're saying is that more evidence needs to be brought to determine whether or not the proportionality requirement is met. And so we don't have the data yet. So what we're essentially saying is we're withdrawing the condition based on insufficient evidence. And so we're not agreeing with the applicant. We're simply saying at this time, there isn't sufficient evidence to make a proportionality showing. And so we're going to wait and see how the property is ultimately developed.
Okay, thank you for that, because I kind of wanted to get that on record. Because it was unclear, since that was the issue that was raised and the takings clause wasn't really addressed, nor does it specifically say, does it specifically address that? It just says we agree with on the issue of the burden. So then that gets back to, I have a similar question or concern that I think Commissioner Coble was maybe also getting at, which is, where does that leave the city and the developer in regards to the construction of a north-south connection? As I understand it, the applicant did propose public access easement in lieu of the north-south connection, and that easement is included in one of the existing conditions. Is that correct?
So I think there is an access easement that was provided by the applicant from 32nd North to Boone. That does remain as a requirement for the subdivision and for development of this lot here. Again, we're recommending removal of the condition requiring dedication or construction of the street on the south side of 32nd down to the southern property.
Okay. Then second question then, what does this do to the denial of the street length of 1,875 feet for that request? Is that still denied?
The planning commission would be essentially approving it. So by removing that condition, we're granting the street connectivity standard to be increased with this application. So there's only, one connection here proposed from 36th.
Okay, I have to sort me through that again. Does that mean that there will be an easement for a north-south connection?
There's no easement requirement here.
Well, I thought that the applicant had proposed public access easement and that was approved in another condition.
That would be from 32nd North to Boone across lot 8. So there's not an access easement requirement to the south.
South. So where then does the 1875 feet?
So I think that would be the distance between 36th Avenue and this proposed, I think it's A Street here. So the distance is roughly 1,800 feet. So our standard again requires streets every 600 feet.
Okay, I'm sorry, but now I'm getting confused, and I ask for indulgence with the other commissioners. But you say the 1875 applies to where?
That's the distance between 36th Avenue and this proposed street.
Okay, so that doesn't have anything, what does that have to do then with the north-south connection that you just showed me? And why, if you get rid of condition 19, does the 1875 denial get overturned?
Because we would be granting relief from the street connectivity standard. So instead of the applicant having to construct streets every 600 feet along the southern boundary here, they're only proposing one street connection here at about 1,800 feet.
So if there's no connection, on the north-south connection on the red line, then there's no reason to deny the 1875. Is that what you're telling me?
Right, that would be the standard that the planning commission would be adopting. Instead of 600 feet at 600-foot intervals, the interval here would now be roughly 1,800 feet.
And I just would it might help to say that this issue does get revisited because lot 12 will come in for a development project later, that the same provisions will apply. And so the same standard, it's not waiving the standard. It's just reassessing it when the site development project comes for lot 12 later.
Okay, again, now reading the staff report, it was not clear to me the relationship between the denial of 1875, because all you say is a condition 19 is removed. It doesn't say anything about the 1875, hence being granted. But let's get back to the same question and the last question of, I'm still unclear then of where this leaves the developer and the city and what risks there are in this. And let's say that we find out that there's a plan and that a street then is required. What happens under that situation?
So we would review any future applications for further development of lot 12. So that could be a land division, it could be site plan review. Like Glenn mentioned, there are street connectivity standards that are associated with those development applications. And we would revisit the street connectivity standard with those applications. And if it's warranted, based on that impact, that known impact of future development, there could be a street connection here in the future.
Okay, and other than the necessity to require permits for that, it would depend on the impact. And then if they could require permits, then they would be required to put in the street the way the city decides. And if no permit, if they can't get the permit, then the issue becomes moot. So the question then becomes, as I think Commissioner Goebel was asking, how does the city protect its ability to, where does the city get assurances that you can do the 60-foot right of way?
Glenn, do you think you can help with that?
The best I can say is that when lot 12 and somewhat lot 11 develops, the same standards apply. And so if that application comes to us, the 600-foot spacing requirement is still the requirement, and it would not be met. And so the expectation is when they come in for something, they'll need to show how they're meeting that, which would likely be a local street. And local streets need to have a 30-foot wide street and a 60-foot wide right-of-way. That's the standard. That's the clear and objective standard that any lot of 12 development would face. And any exception to that would be likely back to Planning Commission for another decision just like that with more information. But compare this to lot 8. Lot 8, we have a development plan. They show an industrial site plan that has parking lots that the traffic can go through the parking lot. So that's not local streets. That's something different. And so when lot 12 comes along and we see what kind of development plan they have, they can propose how they want to meet that 600-foot or near 600-foot standard then. So really, there's nothing lost. It's just delayed.
Are you good, Commissioner?
I think so. Thank you for your indulgence.
Just let me know later if you have another question.
Yeah.
Commissioner Slater, followed by Commissioner Goebel.
Thank you, Aaron. So I'm still lost at the point where the staff could make changes to the connection standards in other instances on this proposal, but not the one that we're looking at now. Can you help me understand that?
So we considered and granted relief from some of the street connectivity standards along the north side of the property, along the east side of the property, due to the size of the property. We do have some development applications here for lot 6, 7, and 8. There's some topography constraints as you start moving further to the west along the property here. So in some cases, I mean, the relief was granted, and the applicant has provided things such as that access easement that allow for bikes and peds to connect between 32nd and Boone that help provide an alternative route other than the street here. So the city did grant in those cases relief from that standard. Again, I think there was discussions with the applicant and there's some unknown about what would occur down here, which is why we led to our initial requirement of the street.
And I'll add real fast that the code language allows specifically for topography or wetlands to be a reason not to do connections. And so you see lot 10, most of lot 10 is a wetland. And so that is allowed in the code. The staff can make that decision with discretion already. It's the lot 12 that didn't have that in the code now.
That was
Thank you,
helpful.
Glenn.
Thank you.
Did you have a follow-up or another question, Commissioner Slater?
I have one other question.
You betcha.
Did the staff get any consideration to setting kind of a parameter or a space, an envelope in terms of spacing where this potential connection could go? So for example, you know, or maybe just saying it needs to go someplace in lot 12.
I don't think we have any specifics for where the right-of-way would have been located here. Again, there's no development plans for lot 12 or 11 or 12. So really the street connection would be unknown. We have it highlighted here as probably the most likely route for where the street would go. But again, without knowing how these are going to develop, it's not known at this time.
You good, Commissioner Slater?
Yeah, I'll come back to that when we have our conversation, but I'm done with my questions. Thank you.
Thank you, Commissioner Slater. Commissioner Goebel, followed by Commissioner Ekus.
Thank you. I'm glad I really apologize, Aaron, but I'm glad that we're able to get a lot of clarification on this. So I'm sorry to be like reiterating some things, but so I just want to confirm that there's no question when it comes to the needed housing issue, the wetland issues, or the topographical issues, but what it comes down to, and the only thing we're really that's really at question is whether or not the city can require this connection without that nexus to proposed development. Is that right?
That was our assessment, yes.
Okay, so I mean, so we've had a number of projects that we have conditioned street improvements based on worst case scenarios, based on land divisions, based on subdivisions, without knowing what that development was going to look like. So can you speak to that?
Glenn, you want to take this one?
The simple answer is each one's kind of independent, and most commonly the developer will propose something that meets the standard, and so staff will accept the proposal as drawn. There are occasions where if they don't meet the standard, they'll have wetlands or topography or issues that are specifically listed in code that would allow for that exception. So each case is different when it comes to the spacing. And in a few cases, and like the Mill Creek Corporate Center was an issue that came up where the parcels are quite different size than these, and so each one has its own unique set of circumstances that get addressed that way. I mean, it's really kind of, we're reacting to the application we get is essentially the simplest way to put it.
Commissioner Goebel, did you have a follow-up?
Yeah, so Aaron said that any development on lot 12, or maybe Glenn said this, I can't remember, so sorry. But any development on lot 12 would require this, would have the same requirements or require the same standards be met as far as the street connectivity and spacing requirements go. So that, so can you clarify that or speak to that? So is there not lot development on, or is there not some types of development on 12 that could not warrant the street connection? Because I can think of a lot off the top of my head that wouldn't necessarily individually warrant the street connection.
A simple example would be, let's say that they go to get a wetland permit and the wetland permit denies any fill of that wetland. And so the way that Aaron has drawn that line, it may have to be something that's more narrow when it comes to the east line. Or it might be that the street has to go along the west line of lot 12 with a bridge across the waterway. There's just some unknowns until we get all the data. We don't know everything that might happen. So that's where when you see a plan with a building and with parking with access, you have more information to apply the criteria. But the same code that we're addressing with this application is the very exact same code that we'll address when lot 12 comes in. So
right,
it's not a new standard, it's the same standard.
I guess to phrase it differently then, so if lot 12, the development that was proposed on lot 12 was something that was so small scale that it wouldn't generate enough trips to require a street connection, is that not something that could happen?
I mean, maybe Aaron can speak to what uses are possible, but yeah, there could be a situation where if I'm sure it's not allowed, but if you just had one home on there that probably wouldn't warrant a street connection. I don't think that's allowed in this zone, but that something like that could possibly happen. But normally speaking, that someday it'll develop to its highest and best use, which would warrant the street.
Aaron, did you want to adjust that or just confirm?
Confirm, yeah. I mean, there are
Yeah.
some low density uses that would be permitted and could be developed right now.
Okay, thank you. Any further questions, Commissioner Goebel? Are you good?
I guess my last question is with fire access. Is there not any issues with the like inability for fire trucks to get to development with like in the center of these large lots that don't have street connectivity?
So when lot 12 does come in for development, fire department will review anything on here and ensure that they have adequate means for accessing the site.
Okay, thanks.
Are you good, Commissioner Goebel?
Yeah, that's fine.
Okay. Commissioner Ekus.
I guess I have the same concern, and I just want to continue the discussion because on the implications of this, because my concern is the same, because I just, if we say in here that since it's unknown, then we're going to remove this condition. And I'm just generally concerned about what's the assessment of the implications that has for future proposals. And what I'm hearing is that, well, we take each one differently in a different proposal, even though some things may be unknown, future development may be unknown, that won't, the same standard or the same conclusion might not necessarily apply. Is that right? Because my concern is that we reach this conclusion, and I'm not necessarily arguing with it, but it does seem to have implication for other cases. And how do we distinguish when something's unknown, whether this analysis applies, or in another case, it doesn't apply?
I guess the one thing I would add, I think, is if we were making a case to say that the topography was such that it couldn't be made, or that the natural features were something that made it so it couldn't be made, then we'd be making an argument that would apply to the next development because there's something about the land. This particular case is not something about the land. It's not something about the natural features. It's about the timing. It's about a term that's used often, and Tom, correct me if I'm wrong, but it's a term that's called ripeness, where it's not time yet. We don't have all the information, so we need to wait. So I don't know. I don't think we've lost anything We just have to wait until the right time. So that's my simple take on it.
Right. It's simply a determination that we don't know enough about the intensity of the development going forward, and so we're gonna wait and see. And remember that, you know, even with a lesser development, this is really a discussion about what can we make them, you know, pay for. And so, you know, if we have, you know, a less intense development, what might happen, and I'm not prejudging this, and I'm not saying it's likely, but what a possibility would be that, well, we're not going to make you build the street, but we're going to make you give us right of way. And so, based on the low intensity of the impact, we would have the opportunity to extract right of way, but then it would be the city's responsibility to actually build the street. All of it depends on, you know, what kind of development comes in, and the intensity of the impact on the transportation system.
Okay, thank you, Tom. I was trying to make sure that we were not, one, conceding the taking clause, and two, not setting up a precedent for future cases that were unknown, where it had unknown properties. Thank you.
You good, Commissioner Ekus?
Yeah, I think so.
Okay, Commissioner Slater.
Thank you. So quick follow-up question to Tom. So Tom, am I understanding correctly that the 600-foot standard may create some constitutional taking issues in a low development context?
If the city can't show that the impact of the development is such that the cost of the thing that you're trying to extract is proportional to that impact, then potentially yes.
Okay, that was very helpful. Thank you.
Okay.
Thank you, Commissioner Slater. Other questions of staff? Of course, Commissioner Goebel will have another opportunity also. But Commissioner Goebel, you've got it.
All right, thank you. So Thomas, I guess, and I know this is a completely different situation, but with the recent zone change request that just got appealed back to, or got remanded back to us from the city council, that did involve, okay, so I'm so sorry, I might get my facts incorrect, and I apologize if I do, so please correct me, but among other projects that we've addressed recently, even, that we have conditioned or required street connections that were not a direct response to proposed development, or that weren't proportional to any proposed development that we knew of, where it was, we don't know what's going to go in here, but we're just basing this off of what you could put in there, and we want you to build this connection or that, you know, street improvement and so forth. And so can you just speak to that? I think that's where I'm still getting hung up is, I guess, why is this case not an instance where we can require a connection based on code standards, even though we don't know what's going to be in there in the future, whereas other projects, we've definitely been able to make decisions that included requiring connections and street improvements even before any development was proposed.
I guess I'm reticent about discussing another matter that's still before the commission and comparing and contrasting it with this one. So I'll just speak in general terms. So, you know, as Glenn said, a lot of times we're confronted with the application that we're given, and you know, so in certain circumstances we have more data and we have less data, and so, you know, depending on, you know, the various factors that come into play, sometimes we're able to say that, you know, well, whatever you're going to do with this, it's going to have this impact, and so we can extract this exaction. And then sometimes we can. And this was a situation where, because these lots weren't being developed right away, and there really isn't a plan in place to say exactly what, how intense that development is going to be. We're simply unable to make the claim and or make the exaction. And so, and you know, it's always a factor that somebody objects. You know, if we ask for an extraction and they don't object, then you know everyone's job is a lot simpler. They've agreed to it and they've done their own analysis internally, and so there's not a lot of discussion about it. And so where we probably could make the you know, the showing, we're not put through our paces because everybody's in agreement in this situation.
Let me add real quick. It might help. Oh, sorry, Lisa's.
Yeah, Lisa's got her hand up.
I'll agree with Tom and not talk about the specific case, but I think it's important to at least say that was a comprehensive plan designation change, which is subject to the transportation planning rule analysis, which requires us to look at worst case scenario under the proposed designation and compare that to the current designation. And then it requires the applicant to mitigate that difference. And then their option, if they don't want to do that, is to limit their uses and their transportation through their uses on their site going forward. So that's just like a totally different application and different kind of analysis, different state law, et cetera, than this case, which is, you know, a land division that's before the commission tonight.
Thanks for the clarification, Lisa. Commissioner Goebel, do you still have follow-up questions on that?
I think so. I agree. We shouldn't talk about any specific land use decisions. But I think that just generally speaking, when you talk about, you know, more data or less data and various factors, I guess what factors or data are at play with this particular application that don't apply to, like, broadly speaking, any other decision that includes conditions or requirements that they do put in street connections? What factors are at play, just so that we can apply it to other, when things like this come before us in the future? I want to be able to take this and say, okay, this is how we know whether or not we can require a street connection, if that makes sense.
Let me try first. So one big one factor is that there can be benefit to the developer to have the surety to know what the ultimate result will look like. And so some developers will want everything laid out and everything decided so that when they go to market their properties, there's no unknowns. And some may choose to have that flexibility. And so sometimes the developer and staff will have quite a bit of discussion to figure out what they're proposing and what. So normally speaking, it's the developer who has that preference. The secondary part of it is that that there's a legal principle that the exaction should come as late in the process as possible. And so, like in a single family subdivision, when you do the subdivision, there's no further land use division or land use action that's going to come. And so the decisions that are made at subdivision are more or less final when it comes to all these issues. With these larger commercial industrial type subdivisions with larger lots, there's a decision to come in either another subdivision or partition or site plan review. So the legal principle is that those decisions, if they can be made later, should be made later. So it's a combination of both what the developer prefers and then what the staff how much information the staff has as to the final development that we can require. So I hope that's specific enough to help you to see that each situation is it gets a little bit complex, but those are some principles that we go by.
Commissioner Goebel?
That's all for now. Thank you. I appreciate your responses on this.
Okay. We'll have another opportunity for questions of staff after we hear from the applicant. So I think at this point, we are ready for the applicant to present for 15 minutes. And please state your name and address for the record or your ward.
All right. Good evening. My name is Mark Lowen. I'm here on behalf of MWSH Boone Road Property LLC, the applicant and developer of the site. Address is 3425 Boone Road Southeast. In fact, our office is directly across the street from this property. Along with me this evening, the rest of our development staff team, I've got Alan Sorum with Suffield Griggs, Mark Grenz, and Natalie Chaney with Multitech Engineering. I'll try to, I've anticipated a few questions based on your conversation this evening. First of all, I want to appreciate the opportunity we have to revisit this land use decision, specifically condition number 19 for our 12 lot phase subdivision. Just to clarify a few things, we do not have any current plans for phase 2 lots 10, 11, and 12. As you saw earlier, as Aaron mentioned, we have plans for lots 1 through 5 to do multifamily along the westerly side of the site, and we have flex and self-storage along the east side of the site. The center section is not even on the drawing board at this point in time, primarily because of the challenges we have with wetlands. It's been a very substantial issue up to this point in time and will continue to be. So with that being said, we definitely support the staff recommendation to modify the administrator's decision in regards to condition 19. I'd like to thank staff for their reconsideration and allowing us to continue to move forward with this development. We are available for any questions, whether it's myself. I know that I wanted to turn it over to Alan because I know Alan wanted to touch on a few items as a follow-up to what I've been saying and to address some of your questions and comments. So I'm gonna mute myself and turn it over to Alan.
Mr. Sorum, name and address, please.
Good evening, Alan Sorum. My address is 250 Church Street, Southeast Salem, Oregon, zip code 97301, Suite 200. As Mark said, I'm an attorney at Suffield Griggs. I appreciate the opportunity to be back before you all tonight. I really appreciate how this planning commission is willing to go ahead and have a little bit of Q&A in a meaningful discussion with staff prior to the applicant testifying, because it allows us to, really hear your questions and narrow our comments tonight as to what you want. Good news is I generally agree with a lot of the comments from Aaron Panko, Glenn Davis, Tom Kupani, and many of the other staff that were able to speak. So this is one of those instances, thankfully not that uncommon, where the common ground is much greater than any kind of points of different opinions on the criteria or the applicable law. Real quick in responding to some of the questions, I agree with the answers from Mr. Panko and others that when we go in for an application, unlike in a residential subdivision, we're going to be subject to the site plan review criteria. And that wasn't always the case in the city of Salem, but it's been that case now for about 10 years. And so the same standards, chapter 803, that staff in this supplemental staff report are clearly pointing to as to what would have triggered the requirement for the particular connectivity road. Those we have to comply with those again in future development. Now, that doesn't mean that we won't be able to provide evidence for an administrative adjustment and not applying the standard based upon the criteria in question, or potentially the issues regarding the cost of the road and the disproportionality will be more clear. One unusual thing about raising issues related to the takings clause is it is referenced in the kind of the preamble of every hearing. So it's our burden to identify any potential concerns or issues with adequate specificity that any of the proposed conditions of approval might violate the takings clause. But once we do that, the burden to establish proportionality, that the condition of approval being required to go forward with the development and the use of the property, that actually shifts to the city. It's not a common scenario, but that is both case law and state law. And so that's why staff has kind of talked about their burden, and that's not something that you typically hear in a land use hearing of a burden of staff. in some way. So it's very unusual. It only gets triggered when an applicant representative raises this issue with adequate specificity, as we did and staff recognized here. So if you're kind of wondering, why don't we hear about this in every hearing? This procedure doesn't get triggered very often. And that's why it's feeling a little bit unusual. But it's not that staff did something wrong in their prior dealings necessarily. Just a little bit about why we raised the issue, why we believe, the land division itself. I think Mr. Davis was the one that kind of highlighted this. The land division itself isn't creating any impacts on the transportation system. Because this is IC zone property, we can go ahead and use and develop it. And what we're looking at is whether or not that land division is a justification to take all of the right of way that's required and or require construction of a 60-foot wide road. And staff recognizing that's a significant cost. And we don't have a lot of evidence yet as to would the public really use that, and would we be there, would we have the type of uses on the property that would justify and triggering that public requirement? Because the city could go ahead and condemn it, but if it did, it would have to pay just compensation for that land. And the city isn't allowed to go ahead and use its approval process or its criteria to, instead of using its condemnation power, taking the land for right of way, requiring us to give it in exchange for the city's consent to the land division. So that's the general gist about the conditions of approval and the takings, and the additional constraints as to why we feel that it would be particularly difficult to implement, and also would not likely generate a huge public benefit or even any benefit to our property, is that we're very concerned that the middle area is not developable in any kind of reasonable time frame. The wetlands, when they are in existence, the most common way to mitigate them would be to make use of any kind of wetlands credits. There's no credits available for the development of that property, which is why it's not even on the drawing board, as Mr. Lowen said. Moreover, there's a waterway just south of our property that creates a barrier to traffic that would go south if that southern property were ever to be developed. So we don't believe that southern property is going to develop in a way where it will be able to have a throughway, and that would require a very long process with the U.S. Army Corps. Staff has kind of commented to us saying, well, we don't really know that to be true. That might be, but it may not be. Again, kind of coming back to where we are in agreement is there's not a lot of information about exactly how long it would take. And while they recognize our concerns about that, they've not conceded that. Maybe if we go ahead and we try to do development within Lot 9 or additional land divisions or some other development pattern, we will develop the record more and revisit that with staff. Just like staff isn't waiving any arguments or claims, we're not waiving anything either. We're all just agreeing that this land division, this subdivision in and of itself isn't the thing that would justify taking the right of way. And so with that, we appreciate the work of staff. We agree that modifying this decision, removing condition 19 is the best interest for everybody and allow us to move forward with both the land division and the surrounding development applications, which were run kind of in separate files, but Mr. Panko identified them on one of his earlier slides. So that's kind of, a quick overview and responding to some of the other questions that I heard. I'll yield the rest of my time and I'm not your attorney, but if you've got questions for the applicant and you want us to elaborate on any of those issues that we spoke to, I'm happy to do my best.
Okay, Mr. Lowen, you have about 5 more minutes if you would like to use that.
I think Alan addressed the rest of the information.
Okay.
We're welcome and available for any questions or clarifications.
Great. So from the commissioners, any questions for Mr. Lowen or Mr. Sorum? If you could raise your hand. Give you a few more minutes to think about it. Wow. They must have saved them all for staff. So I think we're good with you guys. Thank you. We don't have anybody signed up from the neighborhood association, nor do we have any individuals signed up for testimony. So we have our second and last chance for questions from staff, from the commissioners. Commissioner Goebel, you're first up.
Thank you. Okay, so just to kind of put a bow on this, in my mind, I think I largely agree with what Aaron said. I think, or what Alan said. I apologize. I think that this probably doesn't make sense to require that full 60-foot width, and I think that after it's been explained that this is something that will now be evaluated when it comes to the development process. I think that staff is, probably right in that analysis from a common sense perspective. But I do just want to come back to the criteria and the street spacing requirement that, so streets have to have a maximum spacing of 600 feet unless under B, physical conditions, existing buildings. So neither of those apply. The existing public streets terminating at the boundary, that one doesn't apply. And then number 4, that strict application of the spacing requirements result in a street network that is no more beneficial to vehicular, pedestrian, or bicycle traffic than the proposed street network, and the proposed street network will accommodate necessary emergency access. And so in that, I kind of just, I guess, want to raise the question of, is this covered under one of those exceptions? And that's kind of my, just from like a pragmatic standpoint that we're basing it on this. Does there not need to be an additional exception for if we can't yet determine the impacts of development, that's also an opportunity to say that 600-foot street connection requirement doesn't apply?
Aaron, you want to take that, or do you want Glenn?
Sure. I was going to see if Glenn had thoughts on that. I'm trying to pull up the code here.
He's trying to get you to answer that question.
So yeah, I was actually trying to pull up the code as well. I didn't have it in front of me. I don't quite have it all memorized, but so let me make sure I understand. So so your question is, does the removal of condition 19, is that defensible within the existing code language?
That's the question.
That's correct. Yeah. Does the street spacing increase allowance, does it meet one of the 4 exceptions that are listed in the code?
I believe staff has argued that it does not, that we believe it is warranted by those, it doesn't meet one of those 4 exceptions. So I don't know. I mean, I'll look at Aaron for this, but I don't think our findings are saying that it's met one of the 4, therefore is exception. And I think that particularly would probably feed toward the next decision, because when the site plan review decision comes along, then that would really be already committing to saying that it's really exempt. And I don't think we're saying that. So Aaron,
I agree. Yeah. Thank you.
Okay, so I guess, so it's not exempt.
That's correct.
Okay, and now I'm more confused than I was before. I think so we're not making any argument that it's exempt from the street spacing requirements, but we are exempting them from street spacing requirements.
That might be Tom, are you able to answer that question?
You're on mute, Tom.
We're not exempting them. We're simply not making a decision at this time. So we're just deferring the decision until we have more information about what the traffic needs are going to be and whether or not that extraction is proportional to the impacts of what's going to end up being developed.
So I apologize. So can we not make a condition that specifies that street spacing requirements will need to be met unless one of these exemptions are met at this point, right? Because then that, rather than the burden being on the city to find that nexus, that then the burden would then be on the applicant, right, to prove that one of these exemptions exist, AKA if the wetland issue comes into play or so forth. Does that make sense?
Not sure I understand your question.
So, okay, so shouldn't, so right, as it is, if we say, okay, we're just taking out condition 19 and striking it, then now the burden is on the city, and correct me if this isn't correct, the burden's on the city to say, when they come forward with the development application, the burden's on the city to find a nexus, if there is one, for requiring the street spacing connection. Whereas in my understanding, that if we could somehow condition that the applicant needs to prove that one of these 4 exceptions exists, then they would have to go through the process of saying either there's wetlands or the, network wouldn't be applicable under exception 4, or the physical conditions merit it.
Well, it may be that so I think we have that obligation in every extraction. It's just, it doesn't always come up, as Aaron or as Alan suggested, that, oftentimes everybody understands that, okay, this is going to be warranted, and there isn't that conversation. But if we end up having a disagreement with the ultimate developer of these properties about whether or not a connection is warranted, then we'll have to make a showing that it is, there's a nexus between the thing being asked for and that it's proportional to the impact. So that obligation exists. There's no way for us to avoid that obligation if we end up having a disagreement about it.
So your interpretation is doesn't need to be conditioned.
Right. It doesn't need to be conditioned because it's sort of like writing a condition, you will obey the speed limit.
Right.
I was going to say that, Tom. That's one of the phrases I use, is drive the speed limit.
That's right. I stole that from Glenn. So I use
that phrase. It's called a drive the speed limit condition, where it's something that's already required. So discluding it is redundant.
Okay. I think I'm like this close to being on the same page. So I really appreciate, again, your answers to all my questions. Okay. So then, and when we're looking at the code and we're seeing this requirement of the 600-foot maximum spacing and these 4 exceptions, should there not also be a 5th exception, that if there's no nexus or no rational basis for requiring that street improvement, shouldn't that be an exception where the 600-foot spacing requirement isn't required?
Again, because it's a requirement that we have, there's no need for a code section to say that. We have to meet that requirement whether there was a code exception or not. And so because the Constitution trumps the local laws and ordinances, it's baked into sort of the operation of the code, would be my answer. And Lisa can disagree with me if I'm not stating it exactly correctly, but
Lisa Anderson Ogilvie, do you have a comment?
No, I agree with Tom. I mean, it applies to everything we would exact. And so that's not just a street connection, it's a sidewalk, it's water, sewer, anything that we would require a developer to build. So we don't say that anywhere because it applies to all of it, I think. Yeah.
Are you closer, Commissioner Goebel?
I think I got there. I really appreciate you guys. Thank you.
Well, I will go to Commissioner Ickes.
Thank you. I'm convinced wholeheartedly that elimination of condition 19 is proper in this case. However, I'm still a little bit uncertain, and I'm trying to sort out the implications of that for the previous denial of the 1,875 foot length, which is an alternative standard to the code that Commissioner Goebel was talking about. Now, what happens if, as staff said, that if you have condition 19, then that denial is now an approval? what happens if it ends up that you do have to build a street? Is the 1875, since it's been approved, is that still applicable? Or do you have to apply, or will you be applying the existing code and then requiring an application for an alternative street standard to change the existing code? Because that's still not really clear to me, and the staff report doesn't really address the denial of the alternative standard if you eliminate condition 19. So I'm still confused on how those two work together, particularly if there is in the future application and if there is a decision that a street connection is necessary.
Let me try to take a first shot at it. When development of lot 12 happens, the facts of the matter, when that application comes to us, the fact will be that there is only there's the street spacing will be 1,875 feet. That will be a fact that developer will have to then make findings for, to say, well, the standard's 600 and it's 1,875, so that's not meeting standards. So what's your mitigation for that? And it'd be really, really hard for them to say, well, I don't have to do a street because you can't make me. That's a long way from 600. So it would be the very likely scenario that the developer would have to put at least one street in, possibly two, depending on what they're building. So that's just that 1875 is the fact that they're starting from with the next application, and they're woefully short of meeting the standard, and that same code provision still applies. So that's kind of my attempt to explain it.
Okay, let me try and rephrase it so that I make sure that I've got it in my head. Basically, what you're telling me is, despite the 1875 being approved in this decision, if a new street is necessary and they file a new plan that requires the street, the 600-foot code would be applicable, and they would have to file for a alternative street standard instead of the 600.
If less than 600, they would need to demonstrate how they have met that code provision. Yes. So yes, they have
if less than 600, if what is less than 600? If their development plan?
If the streets that, if within the limits of their development, if the street spacing is greater than 600 feet. So for example, half of 1,875 would be around 900 plus. And so to put one street, there will now be 900 feet between the street, between each set of streets. And so that still does not meet 600. And so they would still need to explain why one street's adequate, which then gets into some of the proportionality issues.
Okay, so that's my question. I guess what you're telling me is, despite the fact that by eliminating condition 19, we're actually approving the request for the alternative street standard, that standard will not, they're not going to be able to go back and say, well, this is the standard you've approved.
Yes, the standard 600, it stays 600. The fact that it's 1875 is immaterial to the fact that 600 feet is the standard.
Okay, I guess I'd like to hear from their attorney about if they have that same understanding once we've granted in this order or in this decision the approval of the 1875. I just want to make sure that you and that we're all on the same page here, because it seems to me we're going back and saying, well, despite the fact that you've granted the 1875, because the 1875 is granted because we don't have a condition 19, we don't have a street. But then when we have a street, we're saying, okay, if you do have a street, once you have a street, then the code, the 600 foot applies rather than the 1875 will have approved.
Tom has his microphone off, so on. Would you like to address that, Tom?
Right. So we're not approving 1,875 square feet. We're simply not making a decision about it now.
Well,
because we don't know what's going to happen. So this doesn't give them the ability to say, well, you've already decided this. No, we haven't. And in fact, Aaron was very careful to write into his materials that this is going to be an issue that is going to be considered in the future. So there's no misunderstanding about the scope and nature of the decision you're making today. The decision you're making today is that there isn't sufficient evidence right now to justify an additional condition, and that when this property is further developed, then connectivity issues will again be analyzed, and a determination will be made about how much connectivity and to what extent.
okay, but I understood from previous comments when I asked the question initially, Aaron was saying that the 1875 is then thus being approved.
It is with this subdivision application. It's we're not at the time of future development. We're going to be reassessing the street connectivity requirements for lot 12. But with this application, yeah, there's going to be that one street just with this subdivision.
Okay, is that the same understanding that the applicant has?
Since Mr. Sorum, could you just confirm or deny that, because you did have a few minutes left on your presentation that you didn't use?
Yes, I would say Mr. Capani's summary just now, we agree. We recognize this condition is not going to be applied, whether some future land division will analyze it again. So the city's not bound to waive any code provision, nor is the applicant bound to apply for any kind of future adjustment, variance, anything else. We are just only deciding the tentative plat decision application, and we understand that.
Thank you, Mr. Sorum. Are you good, Commissioner Ekus, with that?
I'm good. I appreciate that.
You bet.
Just wanted that clarification.
No worries. Commissioner Slater, you're up.
Thank you. I don't know if I want to be up. So I totally support the staff proposal. This makes complete sense to kick the can down the road a little bit. What I'm hearing from some of my colleagues, and maybe a little bit of my concern as well, is that our decision today in this particular case may come back to haunt us and be the basis for denying or preventing better connection in the future. I'm wondering, especially Tom, if you have any thoughts on an alternative condition that we might impose that gives us, the commission, some assurance that that connectivity will be included, that conversation will be kept alive and revisited, so that we can go ahead and do that. And you might say that's already in the language, but clearly some of us are concerned that maybe it's not there.
And so I'm going to ask Aaron to help me out here. What exactly did we say about in connection with the removal of condition 19?
What did we say in connection with removal of the condition?
Right. I thought that there was some language in there about that future connectivity would be considered down the road.
That's right. It's not warranted at this time. We can't make the findings that this is proportional to the impact of this development here, but we have in our findings here and included in our recommendation to the Planning Commission is they adopt the finding that at the time of future development of lot 12, lot 11, the future development of these undeveloped parcels, we're going to be applying the code provisions of Chapter 803 and assessing the need for additional street connections when we know when we have a better idea of what that future development is.
Thank you. Just a quick follow-up, and that is based on the 600 feet standard.
Yes, that's in code. Yes.
Okay. Thank you. I'm completely satisfied. I appreciate it.
Thanks, Commissioner Slater. Other questions? I'm not seeing any from commissioners. Give you a few more seconds. And then I'll ask, I think I know what the answer is. Ask, is there any desire from anybody to keep the record open from the applicant's side? Since we didn't have anybody else testifying, and I got it. The answer is no was that you, Mr. Sorum, or is that Mr. Lowen?
That was Mr. Lowen.
Mr. Lowen signified no on that. Thank you very much. In that case, I'm going to close the hearing and turn it over to Commissioner Levin for a motion.
Thank you. I would make a motion that we approve the recommendations by staff to strike condition 19 as applied by the applicant and move the decision forward.
Thank you. Do I have a second?
Second.
Second was, I couldn't see.
Ekus.
Oh, thank you very much, Commissioner Ekus. Discussion on that motion. I think it was pretty clear that we had everything on the record of concerns. Commissioner Levin.
Thank you. I appreciate the creativity from staff on this, and I've waited to share these comments till now. I deal with these standards a lot professionally, and the level of creativity that's applied today, we have not seen historically. And so this, I think, is a great approach by staff and very well adept on this property with the limitations that appear to be there with the wetlands and how whether a true street could be built in the future. So there's a number of different things I could dive into, but generally I have not seen this, and I think this is a huge step forward as compared to, and I think what maybe some folks were missing is that if that street was required today, no matter what gets built, the developer has to do that street today and then hand that over to the city. And then that land may not get developed with the demand and impact of a 400 by 600 grid, which is our city street standards. And so the second comment I have is about a developer having to go to these lengths to get this adjustment approved. This is, in my mind, a very small decision that I feel like should be in the hands of staff to be able to recognize that that doesn't apply today, and we need to defer decision on where that road goes. But I also, I feel that our code needs to be more in depth, and I think I did make a comment to city during our Salem about street standards on this issue. And if we look at other street standards from other communities, they're a bit more in depth. Ours just covers this 400 by 600, which is really in a larger scale, more applicable to residential subdivisions. And so when you look at commercial and industrial applications, it needs to be modified more often, that our code doesn't allow that in a very fluid manner for development. And it would be nice actually if we just had some a broader range of standards that were applicable, so that for something like this that has a mix that is based in industrial but is being applied to be rezoned and changed to other uses as a part of this at least first phase of their subdivision, the core property is industrial. And those standards, unfortunately, more often are the developments that, when they come forward, are having to be appealed at a very extensive rate that it's coming to Planning Commission for us to approve. And I think Mill Creek was referenced earlier. And that's a great example of something that, because of the standards, and if you go look at Mill Creek, it's not developed at 400 by 600. But it can't operate that way. It can't function that way, and it can't provide those jobs for our community that way. And so for a developer to have to go through the extra steps to get the conditions of approval, instead of it just being the standard in our code when you're doing something industrial, I think our city deserves that. And so I would encourage, is just my general comments, that it would be wonderful if we could get that on the list, the wish list of code updates and amendments.
Lisa,
I'll
did you
yield my
hear that?
time.
Lisa Anderson Ogilvie. just checking to see if maybe that has been added to a list. Yay, thumbs up.
Yeah,
Has
it's been on the list for a while.
Okay, awesome. Thank you for your comments, Commissioner Levin. Commissioner Slater.
Thank you. I thought Commissioner Levin's comments were interesting, and I will just follow up when we get to the commissioner remarks point.
Got it. Other discussion items on this motion that's before us? Not seeing any hands raised. Shelby, will you please call the roll, signify by saying aye if you're in favor of the motion, or nay if you are opposed?
Commissioner Augustine.
Aye.
Commissioner Ekis.
Aye.
Commissioner Fott.
Aye.
Commissioner Goebel.
Aye.
Commissioner Griggs.
Aye.
Commissioner Heller.
Aye.
Commissioner Levin.
Aye.
And Commissioner Slater.
Aye.
Thank you. Motion passed. Thanks, Shelby. Moving on to item 6.1 under special orders of business, revision to the Planning Commission bylaws. We did get that in our packet. Tom, are you talking about this brief overview? Or
I think Lisa?
Lisa?
I'm happy to. So a few months ago, I don't remember when it was or what case it was. Maybe it was our Salem public hearing. We had some folks that didn't want to, it was our Salem, right? Yeah, didn't want to say their address out loud, especially since the meeting is live on YouTube and kind of lives on YouTube. And so then we had a discussion after that about changing the bylaws. So we did make some changes. It's 7.2. It's highlighted in yellow of the PDF if you had a chance to see that. So as we discussed, we're just saying that they could provide their address in writing to us instead of stating it out loud at the beginning of the meeting. Generally for land use, we do want to have their address because we are required to send them the decision. They could not give the address, I guess, and then they kind of give up their appeal rights because they won't get the decision. But that's why we ask for people's address. People that maybe testify at council for non-land use stuff are used to just saying, I live in Salem or I live in Ward 2 or whatever, and then maybe don't understand why we're always asking for their address. But that's the change we made. They could do it in writing while we're on Zoom. I think it would be fine that they could just type it into the chat to Shelby.
Is that chat typically open to participants other than us?
I think they can use it and it just goes to you, right, Shelby?
Correct. It goes to hosts and co-hosts only.
Perfect. That'd be great. Yeah. So thanks for the overview. Questions of Lisa on this change, and then I'll be looking for a motion in a second. And I am not seeing, I'm real excited about this. I always felt uncomfortable asking, especially when there's a little bit of reluctance and oh my gosh, there's a reason. There really is a good reason. So I think this is a perfect solution to that situation and meets the needs of a lot of people. So I'm looking for a motion to adopt the change in our bylaws.
This is Commissioner Levin, and I would make a motion that we approve Resolution 22-01 Salem Planning Commission Rules Amendment.
Thank you, Commissioner Levin. Do I have a second?
Second.
Commissioner Goebel is my second. Discussion on that motion. Shelby, would you please call the roll? Signify by aye. Say aye if you're in favor of the motion, or nay if you are opposed.
Commissioner Augustine.
Aye.
Commissioner Ekis.
Aye.
Commissioner Fott.
Aye.
Commissioner Goebel.
Aye.
Commissioner Griggs.
Aye.
Commissioner Heller.
Aye.
Commissioner Levin.
Aye.
And Commissioner Slater.
Aye.
Motion passed. Thanks, Shelby. We don't have any information reports. We have no other public comment. Planning Administrator's report. Lisa?
So the next meeting is canceled on August 16th. We don't know if we have any items yet for September 6th. Too early to know. And then we're planning on that case that's been remanded by the City Council to come back on September 20th. After talking with the applicant, we think that will be the date. Could move around a bit. I don't know if you've heard that the Civic Center is celebrating its 50th anniversary, and there's a big celebration at City Hall on the 18th from 3 to 7. And I believe that the new city flag will be printed and flying there. So
I love it.
Yeah.
And Brian
which
will be there. Former
I-
Commissioner McKinley will be there, I hope.
Yes, I hope so too. And so it'll be, if you don't know, the current city flag, or I should say now the old city flag was created and adopted when the Civic Center was built. So it was done at that same time. So it was 50 years, and now we're gonna usher in, I guess, the next 50 years with the new flag that the council adopted. In the planning division, we've hired 3 new planners. We have 2 planner 1s and a planner 2. It'll probably be a while before you meet them. We try not to make them come to planning commission right away. And we still have 2 more vacancies. 1 planner 3 has accepted a position, and I believe we're going to have another planner 3 as well in September. So we're hoping by September we'll be fully staffed up again, which would be very exciting for Olivia and I. To have so many vacancies has been very difficult. Other than that, I don't think I have any updates. Oh, I know Commissioner Griggs, you always ask about coming back to in person. Yep. So the city manager did adopt a policy that says our director could allow you to start meeting in person. The only hiccup with that is it says the meeting still has to be live streamed on YouTube, even if none of the commission is on YouTube. We meet in the chambers, and it's still not set up for us to be able to live stream the meeting, even if we're all in chambers. It still just doesn't have the technology for that. So the rules, I think, were intended to help the planning commission to be able to meet back in person. They don't quite get us there. I did hear the council say at their last meeting that they plan to be back in chambers in January, because the chambers, the technology will be there to support the hybrid. So we may have to wait until that technology is there before we can meet again in person. In the meantime, I can try to get them to change the rules, or I don't know that I can get them to hurry the technology changes. So it might be till January.
Okay. I think Commissioner Slater has a question for you.
I do. Sure. Lisa, how is your new code enforcement officer with tree responsibilities doing?
Yeah, Roberto's doing, he's doing good. We're keeping him busy. Trees, especially at the moment, since we have this new code, like tree enforcement is more than one person job. Code compliance staff are still responding to tree enforcement complaints, somebody calling and somebody's cut a tree without a permit. They've been very, very busy with that work and follow-up. We are very busy with tree removal permits, because all kinds of trees now qualify for a permit, and then we have to evaluate them to see if there's actually something wrong with the tree versus just, I just don't want this tree in my yard anymore. So, but we're, when we tell people no, we usually do it with giving them their money back to try to be more customer service oriented.
Oh, wow. Well, that's nice.
Yeah, we don't deny, generally for like a tree removal permit, we don't deny it. We say, no, this doesn't meet the criteria, we're going to deny it. Would you prefer to withdraw it and, and get your money back? And usually they want it back. And, for us, it's a couple $100, but for them, it's like, oh my God, that was a couple $100. And then what Roberto is doing, he's doing zoning inspections for commercial, industrial, multifamily. So that can be, it's generally bike racks, parking lots, and landscaping. And so anytime those inspections are called in, instead of a planner, now we have Roberto that goes out to do that. So for landscaping, he is, reading the landscaping plans, checking it, field check to make sure it matches. If not, then he, gives them corrections. Or if sometimes they plant totally different stuff than what their landscape architect, put on the plans, and then they have to submit a revised plan, and we have to make sure it still meets like the trees and the plant, all that kind of stuff. And he's also now going out for single family dwelling inspections. So when they call in an inspection for their house, he goes out to make sure that the trees are planted, or the trees that were supposed to be preserved on the site are still there at final. Really? And so building safety used to do that. Building inspectors used to do that. But as we're finding out, many builders call for inspections and they don't have any trees. And then they're surprised when they don't get their final. And we're like, but see those giant green circles on your plans that say plant these trees, and a table in bright green that says plant 4 trees. And they're like, yeah, the street trees. We're like, no. Your landscaping looks beautiful, and call us when you have the trees. And then he had training. So he's doing a lot of training with the compliance officers on the code compliance part, because we are having people, that he goes out and they were supposed to preserve the tree and it's gone. And so that's an enforcement case. And so he's learning how to do the enforcement on that. And then the city urban forester is also taking him out for training, how to identify tree species, how to measure them, drip line, critical root zone, that kind of stuff. So
That's great. Thank you.
so yeah, it's good to have somebody dedicated to this kind of work that has been a hodgepodge of different people and not any one person's job until recently. So
Lisa, I had a question on Commissioner Slater's and my favorite piece of property on Commercial and Madrona that was finally planted. Were those actually the plants that were on the design, the cactus and the grass and the rocks?
They have not called for an inspection, so we have not inspected it. So they have that is not. I cannot say that what they've done will be approved or has been approved yet. And clearly they're required to have trees, and they haven't put any trees in yet.
No trees. Yeah.
So yeah, but they've not called for an inspection. So either that means that they know they're not done, or they do have temporary occupancy right now because they don't have their landscaping. So if they don't call for an inspection by the end of that temp occupancy, then we call them and say, you don't have final occupancy. What are you doing?
Where are the trees?
Compliance situation on you. So
I know that's what you're thinking, Commissioner Slater. I just kind of, jumped.
I drive by it every day. So
I told Olivia that you would ask me about it tonight. I knew she was talking about it today. I said, I have planning commission tonight. I bet Commissioner Slater will ask about it. I too drive by it every day. So the first time I was like, what are those rocks?
It was a neck turner on the first one. I was like, whoa, what is that?
Yeah. So we don't say how big a plant has to be when you plant it, but you have to have a certain amount of plant units, and the units are based on the size. So people have some options, they can plant, like, for example, a larger bush and less of them, or they can plant smaller bushes and ground cover and more of it to make it up.
Rocks.
So
Lots of rocks.
you can do rocks, or because a lot of people do bark dust, but like the rocks, I think look brighter, so they're more noticeable than if that had been bark dust. But a lot of people do that. So you have to have a certain amount of plant units in the bushes, and then you have to have a certain amount of trees as well. So
those
you
rocks
get
are pretty
flexibility.
climate friendly, though. That's
true. That hardscaping.
Rocks.
Yes.
Hardscaping.
I just came back from San Diego, and it's like I was just thinking, this is very San Diego, where it's just my in-laws don't have any grass anymore. It's all desert plants and just
AstroTurf. San Diego here in a couple years, so
yeah, it's true.
It's true. Any additional information, Lisa, on your report? Is that
no? That's all I
any
have.
questions of Lisa? Thank you for your
very
report.
much.
You betcha. Comments for the good of the order. Commissioner Slater, you had a comment?
Yeah, actually two. I just very quickly want to share that I am now a certified arborist, which means that, I get to label myself with that and be a little bit more opinionated, which I know people will really appreciate.
Yes, we will.
The second thing, and then again, going back to Commissioner Levin about the street standards in commercial industrial, and back to our conversation a few weeks ago, is I think it would be really beneficial if we do create some sort of committee that takes a look at some of these various design standards and expectations related to commercial industrial spaces. I agree with Commissioner Levin that we probably need more flexibility built into the code, but also greater detail in the code. My concern is probably with like pedestrian access in some of these large industrial areas. If we have people coming in by bus or other methods, we want them to have a comfortable environment to be able to get from the bus to their building. But on the other hand, we don't need a street grid like we might in a residential neighborhood for a commercial industrial space. So I think that would just be very helpful if we could do that. I would be happy to serve on a committee. I think last meeting, a couple people expressed some interest. So I'd be interested to see what other people have to say.
And I think, Lisa, when from staff's perspective, when you guys are ready to take on this next revision of the UDC, is that when you typically start to put a group together? I know it won't be Commissioner Levin nor myself, because we won't be around more than another year. But is that generally the approach you take, Lisa?
Yeah, absolutely. I mean, the theme with streets is we are kicking off the TSP update. So some of our policy work around like streets, connectivity, et cetera, should be more framed by the TSP versus just going in and maybe tinkering with the code. We have internally talked about the street standard for an industrial could be bigger than what it is, because it is really geared towards kind of single family subdivisions. So that's, why people can apply for the adjustments, or I guess they're alternative street standards, not adjustments. So I don't know that we have the staff bandwidth right now to bring forward a street chapter amendment. I do think we need to make amendments to our street chapter and our subdivision chapter that we've been talking about for needed housing, because as was kind of touched on today, if it is for housing, every standard needs to be clear and objective. But we do have a lot of standards that say like, build this to the specifications of the public works director, or, make this walkable or what, and so we need to make some of that clear. And so we've been talking about that. We just haven't had the staff bandwidth to kind of tackle that. But the TSP, there has been discussion about having a committee for the TSP. The council talked about it last week at their policy agenda meeting. I don't know if anyone watched it. No, you can go watch it on YouTube. They talked about having a committee for that and for Goal 5, and because of their desire to be on it as counselors. So I assume if a committee is formed, then we can get planning commissioners on there. I think that would be appropriate for those two projects as well. But I think that council discussion was before staff has even kind of wrapped their head around scoping those projects. But we're starting that very soon, or I should say Public Works is starting that very soon with planning's help. So
I total nominate Commissioner Slater for any of those committees.
All of the committees.
Don't let Levin off the hook.
Oh,
If I'm sorry, I had to change locations because my computer was running out of battery. If I'm still on the commission, I will gladly sit on that committee.
Yeah, got it.
Thank you.
Did that conclude your, yep, I must have. Any other comments for the good of the order from commissioners?
I have two comments. So
Sure.
One related to that. So with the new policies related to climate friendly cities, are we planning, or has there been any talk around having a committee to talk about implementing the climate friendly communities rules?
No, we don't plan to have a committee. We've already started the work. We've signed a contract with the Council of Government staff to do the technical analysis of identifying the climate friendly area, because it's analysis of like housing units in an area. We believe from our initial analysis that which is just one part of the rules, that most of downtown and the areas around it that are zoned for mixed use will already have the right zoning in place to be climate friendly area. So they're going to do that technical analysis. And then there is some outreach components that we're going to do. Generally in planning, we decided after phase 1 of our Salem that committees, which take a lot of staff time to staff and like aren't a great use of our time as far as outreach, because we don't we would rather use our time to do outreach to the community directly. So we haven't really been forming committees. I don't know that there's most of the climate friendly rules at the beginning are going to be in the TSP, because a lot of them are about TSPs. And since we're doing ours, we're probably going to be the first city to even have to do those rules before we'd even have to. So that's where we've really been focusing. And I think there's a kind of a policy decision for the city on parking, because there's a lot of parking stuff. And one path is just don't require parking for anything. And then you're kind of check that box and then you're kind of done with the parking mostly. And the other path is like, do these 800 billion things for parking. It's like, which one do you want it to do? State of Oregon. So, we're going to ask the council later this fall, their direct, what direction they want us to go on that. But we're still trying to wrap our head around all of it. There's a lot of components and a lot of timelines for it. So all that's to say is that any code amendments that come out of it, which we think would be pretty minimal, again, for climate friendly areas, would come to Planning Commission. But we were keeping those rules in mind when we were working on our Salem. So if the first analysis by COG comes back and is like, oh my God, no, you guys are way off in your initial analysis and half the city has to be rezoned for climate friendly area, then I'll report back and we'll have a lot more work than we were planning on doing.
But that's not anticipated.
Not
No.
anticipated. No.
Daisy, Commissioner Goebel, sorry, you've had a second question?
Yeah, my only other question was with regard to filling the vacancy, has there been any talk on appointing another planning commissioner?
Yeah, I think the boards and commissions committee, council subcommittee is not planning to meet till September. I did express my displeasure because we've had a vacancy for a while and had some quorum issues, but no one really cares about my opinion. So I don't think it really, riles the mayor to bring them together. You know, a lot of counselors are gone in the summer and August, especially, and it's hard for them to meet. So they plan to meet in early September. I do think I did see that more applications have been coming in. So I know there already were applications on file because they last for a year. And then I saw 4 more that have come in, and there might be more that kind of sporadically forward them to me. They don't come directly to me. So, and I saw that the communications team had put it on like community connections and city Facebook and stuff. So maybe they're just waiting to get a big group of applications or something. But in theory, when they meet in September, they will be picking people to interview.
Awesome.
Thank you, Lisa.
Any other questions or comments for the good of the order? If not, guess what? We're adjourned. See you guys.
Thank you, President.
Thank you.
See you, bud. See you guys.